We begin with this historic impeachment trial of Attorney General Ken Paxton. He now becomes the third person in state history to face this potential political career-ending event. Ever since he was impeached on Memorial Day weekend, Paxton has been suspended from his job without pay. If he's convicted of just one of the 20 articles of impeachment, he will be removed from his job permanently. That's up to the senators, who are the jurors, and they could also decide whether to keep Paxton from ever holding office again in the state. On the first day of the trial, some key decisions. As expected, Paxton pleaded not guilty to all of the articles of impeachment. Lieutenant Governor Dan Patrick decided Paxton would not have to take the stand to answer questions and would not have to stay in the chamber during the trial, and he hasn't. And senators decided overwhelmingly against dropping the articles of impeachment against Paxton by a vote of 24-6. Those 6 senators who voted to drop the articles of impeachment are Republicans: Paul Bettencourt, Donna Campbell, Brandon Creighton, Bob Hall of North Texas, Lois Kolkhorst, and Tan Parker of North Texas. Numbers are key during the impeachment trial. To convict Paxton on an impeachment article, there needs to be 21 senators to approve. There are 12 Democratic senators and 18 Republican senators who can vote. The 19th, Senator Angela Paxton, the Attorney General's wife, cannot vote because of her conflict of interest. And with 6 Republicans already voting to drop all the articles of impeachment against Paxton, his defense team may only need to convince 4 other Republicans to side with them. And then it was time for opening statements from each side. My colleague Andrea Lucia reports from the Capitol.
As the overwhelming evidence will show, he is not fit to be the Attorney General for the state of Texas.
First up was Representative Andrew Murr for the House impeachment managers. He took just 17 minutes, leaving the prosecution more time to question witnesses.
These witnesses will explain step by step how they discovered that Mr. Paxton grew increasingly intent and passionate about helping his partner, Nate Paul.
Murr says Paxton's own former top aides will detail their accusations that he handed the keys to the Attorney General's office over to Paul, a donor who allegedly paid for Paxton's kitchen renovation and helped him conceal an extramarital affair.
It's a tale full of sound and fury. It signifies nothing.
Ken Paxton's attorneys used nearly the whole hour allotted to them to attack the allegations against Paxton, the House impeachment managers, the House Speaker, the Lieutenant Governor's gag order, and the press. Even the integrity of the senators serving as jurors was called into question.
Cases are supposed to be decided only upon the evidence. But I do wonder, are we really going to get a fair trial here? Have you already decided based on what is politically expedient or what's best for you personally?
Paxton's attorneys also questioned the impeachment process itself, calling it an effort to overturn the will of the voters.
Your decision is much bigger than Ken Paxton. Your decision is literally about democracy in this state.
The Founding Fathers debated and rejected the idea that elections could singularly protect the public against abusive office holders. In other words, drafters agreed that impeachment was and is necessary.
During the testimony, some of Paxton's former top deputies in the Attorney General's office expressed their deep concern about the Attorney General's activities. Specifically, their beliefs that Paxton was abusing the power of his office and authority to benefit Nate Paul, an Austin developer who had donated $25,000 to his campaign in 2018. All this at the expense of the public. Some of the articles of impeachment against Paxton accuse him of misusing his office when it came to having the office write a legal opinion that would help Paul with regard to foreclosure sales during the pandemic and grant a public information request to Paul's attorneys that would have disclosed a sealed FBI affidavit against Paul. Former First Assistant Attorney General Jeff Mateer, Paxton's top lieutenant, was first to testify for the House impeachment managers.
The problem is the office is being used for the benefit of one person. It's not exercising its own independent judgment. You have the Attorney General acting on behalf of one person, and by this time, I knew that he was a campaign donor.
Another impeachment article involves Paul hiring Paxton's alleged mistress, which House prosecutors say helped the Attorney General out so he could see her in Austin instead of where she previously lived, which was in San Antonio.
Because it answered the question, why is he engaging in all these activities? At times I thought, is he being blackmailed? I mean, this was so unlike what I experienced with him for 4 years. And this was part of it. There may have been more, there may have been others, but this was certainly part of it.
But during cross-examination, Paxton's top lawyer, Tony Busby, accused Mateer and others of trying to overthrow Paxton.
You were involved in staging a coup, weren't you?
Absolutely not.
That's what you were up to.
Absolutely.
That's the reason you went to the governor's office. You were staging a coup, weren't you?
Absolutely not.
Ultimately, he and 7 other top deputies in the Attorney General's office went to the FBI with their concerns in October 2020. Busby asked Mateer about that.
Is it possible, Mr. Mateer, that you jumped to a lot of conclusions really fast?
I don't believe so, sir.
And you could have put all this to bed if you'd just talked to your boss.
I attempted to talk to him starting probably in June, July, August, September.
No.
I did.
Take it easy.
I did talk to him, sir.
Another top deputy in the Attorney General's office, Ryan Bankert, was asked by the House lawyer why it was that they went to the FBI.
The Attorney General was determined to follow this course of action in favor of Nate Paul, despite all of our efforts to persuade him otherwise. The power of our office had been fully, at that point, harnessed to advance Nate Paul's interests, and we had lost the ability to, as senior staff, protect our principal.
Why didn't you go to the Attorney General, just talk to him? Did you?
Concerns were raised repeatedly and consistently by multiple members of senior staff over a course of several months. There is no question in my mind, based on my personal experience with him, that he was well aware of our objections.
Paxton has repeatedly denied any wrongdoing, and his legal team from the start has called the impeachment a sham. We'll delve deeper into the impeachment trial coming up in just a bit, but first some other headlines across Texas. ERCOT, the operator of most of the state's power grid, issued an energy emergency alert 2 for about an hour Wednesday evening. Authorities said power reserves dropped below a certain level, and they had to use additional resources to protect the reliability of the grid. No controlled power outages were conducted, but ERCOT did ask Texans to do their best to conserve power from 6 until 9 p.m. Operations returned to normal. A federal judge in Texas has ordered the state to remove its buoy barrier in the Rio Grande by September 15th. The judge said the state needed federal approval to place the barrier there. Governor Greg Abbott has said he believes the state is on proper legal ground and vowed to take this all the way to the U.S. Supreme Court. The state has appealed the federal judge's ruling. The trial of suspended Attorney General Ken Paxton may take several weeks. So how are the lawyers for the House impeachment managers and for Ken Paxton doing when it comes to questioning the witnesses and making legal points for the 30 state senators who are the jurors who will decide Paxton's fate? I spoke with appellate attorney David Cole of Dallas. Appellate attorney David Cole of Dallas, thank you so much for joining us as always. We appreciate it. So let's start right in with the impeachment trial of Ken Paxton. And just even before it started, some very key decisions were made. Paxton not having to answer questions and take the witness stand, and the fact that he doesn't have to be there every day, and he hasn't been really during the testimony. And I'm wondering what your thoughts are about that from a legal aspect.
Those are two tactical wins for Mr. Paxton. Of course, if he had to testify, be compelled to testify by subpoena, he would likely have been the first witness in the House manager's case. They would have asked him a lot of questions, and he would probably have been forced to take the Fifth Amendment to protect himself in these other criminal matters that he has, and that would not be a good look, hour after hour of him asserting that. But he got a good ruling from the Senate that said he did not have to testify, so he doesn't have to deal with that Fifth Amendment issue. That's a plus. Him not having to be there is a minor plus, but it's still a plus. There's a lot, those cameras have certain angles, and you see the same people over and over again. And if he's in the room, everybody's going to look at him. He's a distraction because he's so central to the proceedings. So getting him out of the room sort of makes things even, I think. His lawyers can just go along and no one's going to be too preoccupied with looking at lawyers. So I think that's helpful to not have 3 TV cameras trained on him at all times and everybody staring at him. Now, the bigger question, though, is strategically, what does that signal about where the Senate may be going on the merits of the claims? That's kind of tea leaf reading, but that's part of trying to understand these pretrial rulings as well.
Yeah, I was going to ask you about that, but I wanted to just ask you, the other Paxton, Senator Angela Paxton, is there as required by the Texas Constitution, even though she's not able to vote because of her obvious conflict of interest. And so I'm wondering, the fact we see her sitting behind the House impeachment lawyers. And so we get a very clear view of her. What is any legal impact of that? Obviously, she's there for all the other senators to see, but for people at home, et cetera.
Not really. I think she's obviously well known in Texas politics, but it's not the same thing as being the defendant. I think she's skilled at media, and she's not going to have too much slipping out of her poker face in reactions to things. She was able to get some minor positives out of being there in Mr. Busby's opening, kind of joking around with her a little bit about this granite countertop stuff. But I think she doesn't want to call any more attention to herself than she already, has by virtue of her position. She seems to be playing it that way, and if she starts interacting too much, people are going to object and complain she's trying to interject herself in the proceedings. So I don't think it's particularly distracting in the big scheme of things, and it's in her interest to just stay as much of a potted plant as she can.
Let me ask you, you mentioned the reading of the tea leaves. 24 of the 30 voting senators, including most of the Republicans, said that the trial should go forward and that the articles of impeachment should not be dropped against Ken Paxton. What did you make of that?
Well, different people have different reactions depending on their experience. I will say in many cases I've been involved with, when a judge is not inclined to rule for you on the merits of the case, they will often give you the benefit of the doubt on procedural points, trying to take away things you can appeal on. So they let you introduce this exhibit, they let you ask this question, and that way at the end of the day, when you lose on the merits, you've got fewer complaints you can make about that judgment. Now, you can hypothesize that maybe that's what happened here, because the margins of these votes were all in favor of letting the proceedings go forward by more than 21 votes, the impeachment threshold. So that suggests a pretty solid consensus to at least be moving forward in the Senate on these, not put it off to one side. It could be that that's a signal that a majority of the Senate is predisposed to accept the House manager's side of things, and they're taking away things that Mr. Paxton could potentially complain about afterwards if it doesn't go his way. There's another perfectly reasonable view that could say a majority of people just voted for it. So if they could say, we went along with the process and then vote for Mr. Paxton at the end of the day, and that way try and please everybody a little bit. And some people, it may be a mix of all that. So different people's litigation experiences leads them to read those tea leaves in different ways, some pro Paxton, some against Paxton, but it's all just tea leaf reading.
And what has stood out on each side, the House impeachment manager's side and also the Paxton defense side to you? What are the strongest points do you believe that each has made?
So we're just getting started after just 2 witnesses. It's the 2 witnesses the House has called so far are strong on their overall credibility. These are people they're serious people. They're clearly committed to the conservative cause. They came to Austin because they thought they were part of something bigger than themselves. They're obviously disappointed with how that went and how they feel they were treated by Mr. Paxton. That comes across pretty loud and clear from them. And they did something that was obviously not in their interest, which is going to law enforcement about the boss. A strength that's come out on the other side, though, is that what is often the strength for a defendant in the case is to push the details. Okay, great, you've got these people who are unhappy, but what do you really know about this? And what do you really know about that? Did you know the entire picture? And I think a theme that you see developing in their examinations is you have a lot of people that got upset that were under stress, that got angry, and to use Mr. Busby's words, jumped to conclusions without knowing a set of facts. And I think the defense is at its strongest in this case when it's talking about, did you know this? Did you know that? What about that? It's at its weakest when it's trying to challenge credibility overall of these witnesses who, seem to be very sincere about what their beliefs are.
I mean, at the end of the day, legally, it's the House that has to prove this case beyond a reasonable doubt. And so the Paxton legal team is really just trying to sow doubt in the minds of these senators.
Although, to be frank, the standard's whatever they want it to be. I mean, the Senate just has to take a vote. The argument that Mr. Paxton's side has made is it should be beyond a reasonable doubt because it's like criminal law. You should think of it that way. But there's no reviewing court that's going to sit in judgment on what the Senate does and say, well, you didn't fairly apply a reasonable doubt standard. I mean, the way they vote is pretty much the way they vote. Now, what they can do when they go back to their constituents is say, I treated it as a beyond a reasonable doubt standard and didn't think that was satisfied. And that would be an explanation they could give that might satisfy some people that might otherwise be dissatisfied with their representatives.
I wanted to ask you about some of the points that, each of the witnesses made. Jeff Mateer, who was Paxton's top deputy, the first assistant, before resigning. He basically, they were talking about one of the articles of impeachment in which Paxton is accused of causing a legal opinion to be written to favor Nate Paul, one of his campaign donors, and who's at the center of this, and who Paxton is accused of trying to benefit, of writing this legal opinion to prohibit foreclosure sales during the pandemic to benefit Paul, whose properties were coming up for foreclosure, some of them. And he said, Jeff Mateer said how it was very strange that this opinion was the exact opposite of what the office and the Attorney General himself had been trying to do, which was reopen the state of Texas. And Mateer said, quote, as if it was as if Anthony Fauci wrote this legal opinion. How damaging do you think that was?
I thought that was one of the stronger moments of his testimony. And it was similarly one of the stronger points of Mr. Bangert's testimony, who actually, was kind of in the trenches putting that letter together. One of the reasons why I think it's powerful is it goes to the heart of what impeachment's really about, which is, was there an abuse of power? It's not, did he do something with his countertop or something, but was there something done with this office that was unbecoming, that let down people of the state? And if high-ranking officials in the office can say, our office as an organization was trying to do this and was spending a lot of time and energy trying to do this, and all of a sudden the boss has us run off over here doing that, which is intellectually inconsistent and practically inconsistent because people are running around on that instead of doing another job. That's probative of that very basic fact that the office wasn't being used the way it should have been on something that's the core of what the Attorney General does, which is produce that kind of guidance and opinion letters. So I think that's one of the stronger points the House managers have developed in the testimony so far.
Now, during cross-examination of Jeff Mateer, Tony Busby, who's Paxton's lead attorney, came back at him and saying, well, it said at the bottom that this was not a legal and not a formal opinion of the Attorney General's office, and made the point that it did not stop or prevent any foreclosure sales from taking place. But then Bangert, in his testimony, Ryan Bangert, who was another former deputy, basically said that he was the one who inserted that language, that it wasn't a formal opinion because it did not go its normal rigorous review, which normally takes 6 months. This happened really just over a weekend.
Yeah, there's a couple of, it was interesting to hear the back and forth about that. I do think the defense succeeded in blunting the impact a little bit with those questions, because while it may have been inconsistent what the Attorney General was doing, maybe didn't have that much impact at the end of the day. But I came away from Mr. Bangert's testimony about that feeling sympathetic for him and understanding another theme that runs through the House manager's case. In the cross-examination of these two witnesses, you've heard the defense lawyers say, what, you signed off on this, you participated in this. If it's so unlawful, what were you doing being involved in it? And when Mr. Bangert said, I had to do all this work, but I slipped this in there to try to make myself have a clean conscience about what I was doing, that it wasn't binding, that illustrated to me the kind of pressure he felt he was under and the conflicted signals he was getting, conflicted duties he felt he had. And that, I thought, was a good example at a human level of what the House manager's case is all about. The office was just behaving strangely for an administrative agency of the government. And I get the argument on the defense side that, look, it didn't really do all that much in the big scheme of things. That's a fair point, and there was some discussion about that today. The counter argument is, well, I mean, just because the bullet missed doesn't mean that there wasn't intent behind pulling the trigger. I mean, the office is still supposed to be doing its job, and whether or not it just didn't work out to be that bad one day isn't really the relevant question. That's for the senators to decide, though.
My last question to you is, and I certainly appreciate the analysis, you know, one of the other major themes that we heard yesterday and a little bit today, this being Thursday afternoon as we speak, and that is the fact that Paxton's legal team, the lead lawyer, Tony Busby, yesterday basically asked Jeff Mateer, the former top deputy, were you trying to overthrow Paxton? Were you trying to get him out of office? And Mateer denied that, said absolutely not. And he was also asked, why not just go to and talk to the Attorney General? And he, you know, raised his voice at one point saying he got, you know, he was upset by that. And even Ryan Banker today was asked this question by the House impeachment managers, why not just talk to Ken Paxton about it? And he said that they tried, that there was nothing else they could do. They had to go to the FBI to report this. And I'm wondering what your thought was on that.
Yeah, it's you know, there's fair questions both ways there. Why didn't you handle it a different way? And I think the best way that Mr. Bangert and Mr. Mateer went about answering that question is just explain what they did and say, well, we had this meeting and this conversation and this discussion, and I was just talked out by the end of the day. Could I have talked more? Probably, but I just didn't think I had anything left to say after the conversations I'd already had. Cross-examination suggests, well, maybe you could have gone a little bit further. It's a classic credibility type question that the jury has to decide here, these senators has to decide. But there isn't much question from the testimony that there was pretty intense conversation back and forth between these guys and Mr. Paxton about this preparation process. So the other part of that has rung a little off key to me in hearing the questioning is this business about a coup or trying to overthrow the Attorney General or something like that. It's a challenge for the defense here because they've got to take these whistleblowers, all of whom seem to be sincere and who appear to have acted against their own self-interest, and explain why they did it if they're wrong. And they can take one of two tacks, and you heard those both in the examinations the other day, which is you can go flat on out and say you guys were trying to have a coup and overthrow the Attorney General, or you can say you're just all profoundly mistaken. The coup thing has been a hard sell. It just seems to kind of bounced off these witnesses. They don't seem like coup leading types of people. That leads you back to mistake. But then, you know, who does all that just because they're acting in a hasty generalization and they're mistaken? It doesn't seem like the actions of people who believe they're mistaken. So that's a challenge for the defendants is if the whistleblowers are wrong, why are they wrong? And you're trying to have a coup is just not really resonating with these people. They just don't seem like they're having a coup.
Appellate Attorney David Cole of Dallas, thank you so much. We really appreciate it.
Thank you.
This may be a trial, but ultimately the impeachment of Ken Paxton is political. There are 30 state senators who will decide whether Paxton will be permanently removed from his job and possibly never be able to hold elective office in Texas again. We spoke with Dr. Joshua Blank of the Texas Politics Project at UT Austin. Dr. Joshua Blank, Research Director at the Texas Politics Project at UT Austin. Thank you so much for joining us. We appreciate it as always. So, the politics of impeachment. We've had several days of this trial, and I want to know, what are your thoughts about the fact that Paxton does not have to stand trial, does not have to, in other words, he doesn't have to take the stand and answer questions. And he doesn't have to be there and hasn't been after the morning of the first day in which he entered his not guilty pleas on all the articles of impeachment. So what do you make of those things?
Well, I sort of have, I think, diverging responses to them. I think with respect to the Attorney General not having to take the stand, I think in a lot of ways that's going to make a lot of sense. I mean, I think if you watched the way that the Lieutenant Governor responded to the question, essentially what he said was, look, the Attorney General should not be forced to testify in this case, as most defendants in a kind of criminal trial would not be forced to the stand. And so I thought, it would have been a long shot to begin with to force the Attorney General to testify under oath in the Texas Senate. I mean, as high profile of an event as that would have been, and as much of attention as that would have grabbed, it's not necessarily what we think of as a normal and sort of standard process for, I think, a trial in America. So I think in and of itself, that was not so surprising.
And what do you make of him not being there?
Well, look, I think it's a doubling down on the political strategy that the Attorney General has taken from the beginning, which is to take these charges and these accusations as somehow unserious. And I think, by not being there, he is giving a physical representation of his orientation towards the charges in the trial, which is that it's not really worthy of his time. Now, there's a political side to this too, which is I don't think he wants to be sitting there while all this is going on with every single reporter watching to see any reaction he might make to any of the testimony. At the same time, this is not merely a criminal trial. This is a political trial, and the jurors are senators. And so one of the things about the strategy is, while it may be sensible in terms of how it looks to the outside that he's sort of not taking this as seriously, to the senators who are taking this very seriously and who themselves are forced to be there every day to listen to the back and forth between the lawyers over witness testimony and a lot of really arcane questions about hearsay and other aspects of the law, they might find it rather frustrating that the person actually accused of these actions and the main reason that they're sitting there basically gets to watch from home.
And the math of impeachment is very important, is it not? Because here you have 24 senators of the 30 who can vote decided that all of these charges should not be dropped, as Paxton's legal team had requested. 6 Republicans said they, in a sense, should be dropped. And so I'm wondering, politically, what do you make of that?
Well, I flip it around. I start by looking at the 6. I think when we were watching, there were, I think, 16 motions that were offered before the trial that would have dismissed some or all of the charges. And by the trial rules that the senators adopted, they would have to vote on those individually on their own. In other words, the lieutenant governor could not dispense with those motions. And I think, that was an early test of what Paxton's support looks like in the Senate. On none of those motions were there fewer than 6 votes, basically to move to essentially acquit the Attorney General of all charges. And I think we can understand that as essentially his baseline of support. There's certainly 6 members in the Senate who would vote to, I think, acquit on all charges. And I think that's clear from what we saw earlier in the week. But he needs 11 votes. And so on some of those motions, he was able to get to 10. On some, he was at, I think, 8. But what it says to me is that absent, basically being acquitted earlier this week, which would have been the best case scenario for the Attorney General, the second best scenario in some sense is where he is now. I think he knows that he has somewhere between 6 and 10 Republican votes to acquit him. And then the question becomes, who is he going to convince, whether through the trial process, through the outside pressure of his allies, to come along. I also don't think that the 24 votes to move forward are necessarily 24 votes to impeach or to convict on the impeachment charges. And I think that there's a very good possibility that some number of those Republicans, and we don't know how many there will be, but some number of those Republican senators will very comfortably at the end of this trial say, these were serious charges. We gave them a serious hearing. And having heard them, we don't feel like we have enough information to overturn the will of the voters. And some of those votes are going to come from among senators who voted to move forward with the trial nonetheless.
You mentioned before, we've got 31 senators, only 30 can actually vote because Senator Angela Paxton, Paxton's wife, is not allowed to do so because of her obvious conflict of interest.
Mhm.
And so you've got 12 Democrats who can vote. You got 18 Republicans who can vote. Assuming, if you will, that all the Democrats will vote to convict, then they need, on their side, the House impeachment managers need 9 Republicans to get to 21, which is what the required vote is to actually convict. And so it leaves anywhere from about 4 Republicans that they've got to sway to their side on all. They got to go through all these cases. And so I'm wondering, and conservatives are keeping track. The Defend the Texas Liberty PAC is, sending out daily emails on which senators are where. And I'm wondering about the politics and the political fallout from that, and the impact of this outside group doing that.
Well, I think there's 2 answers there. I think first, it's not, controversial to say that most elected officials are single-minded seekers of re-election. And that is the main factor that I think is going to condition most of the decision-making here. And I know that sounds crass in some ways or maybe cynical, but I think the question becomes for a lot of these Republican senators, is there greater exposure in convicting the Attorney General, or is there greater exposure in not convicting the Attorney General? And right now, the Republican electorate has not been clear or giving clear signals on that question. So, I mean, the politics of this very, very, very much matter. At the same time, you mentioned the pressure of outside groups, which has been enormous. And I want to make a point here. It's also asymmetrical. There is not a group spending a ton of money on behalf of the House managers arguing in the districts of these, potentially persuadable jurors that they should convict Attorney General Paxton, where there is a lot of money being spent coming to his defense. Having said that, the types of groups that are spending this kind of money and really putting this huge full court press on these members have been remarkably unsuccessful electorally in the recent history of Texas politics. These are the same groups that make a lot of noise around primary time and during the legislative session about all of the members they're going to primary, all of the rhinos they're going to clean out. And ultimately, when you actually go and look at the record of candidates they support and their actual success rates, they tend to do pretty poorly. This group that they've sort of most supportive of in the House, the Freedom Caucus, the sort of the far right Republicans in the legislature, is not a group that's grown substantially over the last decade, despite seeming unlimited financial resources. So while I do think there is a sort of untoward nature and asymmetry here in terms of the pressure that's going to be felt by Texas's senators / jurors in this trial, I also think that they can look at the record of these groups and sort of maybe temper their response, knowing that in general they've been less effective than they've been loud.
You and your organization did a poll right before the start of the impeachment trial. And what did that poll find? What are the things that you found stick out as far as how the general electorate feels and Republicans specifically?
Yeah, I think there's 3 main things I'd highlight. The first is to note that this is not really a top of mind consideration for most voters right now. When we look at how much attention people were paying or how much information they were hearing about this, there was an uptick from before the impeachment to after the impeachment. But since the impeachment, when we polled in June and August, despite all the attention that, I think, primarily people like me are paying to this, most voters were not paying any attention. We're going about their summers as if none of this was happening, which I think we should expect. We'll see whether that changes over time. But right now, a lot of voters are just really starting to pay attention to this, if at all. Another thing we found was almost half of voters think that Ken Paxton probably engaged in actions while Attorney General that deserve removing him from office. 47% said that he should be removed from office based on what they've heard about what he's done. 18% said he shouldn't. 35% unsure. When it comes to Republican voters, and this is, I think, one of the real key findings of the poll, is they are still reserving judgment. When we say, did Ken Paxton take actions while Attorney General that justify removing him from office, the plurality, 43%, say they don't know, they're not sure. When asked whether the Texas House was justified in impeaching Ken Paxton, 39% said they're not sure. That's the plurality again. The only sort of silver lining for Ken Paxton in all of this is the fact when asked if the investigations into Ken Paxton are either, on the one hand, mostly based on the facts, or whether they're mostly based on politics, a plurality of Republicans, a near majority, 48% say it's mostly based on politics. I think this is a reflection of years now of Republicans, but in particular, Donald Trump really contextualizing these legal proceedings against especially Republican elected officials as merely politics. There's a ready audience to accept that frame. And I think actually you're seeing the defense in a lot of ways in the Paxton trial, if you've been watching closely over the first few days, really honing in on this idea that this is about politics, this is about coalitions, this is about essentially George P. Bush, Texans for Lawsuit Reform, Greg Abbott, and everybody but Ken Paxton. Now, that's an outside strategy. Does that work on the senator jurors? I'm not so sure.
And that's really the obvious. Those are the people who are going to be making the decision. That's where they're going to be the ones deciding Paxton's fate. And my last question to you is, I know it's still early in the trial. Is there anything that you've heard so far that you think is helpful, especially to one side or the other?
I don't know if it's something that I've heard, but it's something that I've sort of realized, and it's obvious, but I think it's interesting, which is it's important to point out, I think, if you are watching the trial closely, which is it's important to remember that the defense here does not need to prove that that Ken Paxton is innocent. They don't need to prove that everything he did was above board or not ethically challenged or whatever. They literally just have to sow doubt. And so if you're watching and kind of thinking about what am I watching here, what's going on, you have a prosecution that's trying to lay out how a bunch of different instances of behavior can be put together to paint a picture of a failure of ethical conduct at the very least, and maybe criminal conduct at the worst. But for the defense of Paxton, really all that needs to happen is doubt needs to be sown, and you're seeing that happen in a couple different ways. But in some ways, it reminds you of the fact that the judicial system, whether this counts as that or not, really does place the burden of proof on the House managers in this case. And I think the one thing I'll say after a few days is, that's going to be a high burden to clear, I think, in this Texas Senate.
Dr. Joshua Blank, Research Director at the Texas Politics Project at UT Austin. Thank you so much. We really appreciate it.
Thanks for having me.
That's all for Eye on Politics this week. Thank you so much for joining us. I'm Jack Fink. I'll be reporting from Austin starting on Monday. You're watching CBS News Texas.